Okay, so that's some testimony that you may have missed because we were live this weekend. We are in verdict watch in the Jessica Chambers case. We are hopefully going to be live there today with a verdict, so you don't want to miss anything. But I want to talk more about what's happening right now in jury deliberations. Joining me right now is Law and Crime trial analyst Jonna Spilbor, who's here back with us on a Monday morning. Good to see you.
Good morning. Good morning, everybody.
So the jury deliberated for about, I want to make sure I get this right, I think 4 hours and 45 minutes. They sent a note out to the judge. Do we have to come with a decision tonight? He said, if you can, that would be great, but if not, you can continue on tomorrow. This is weird, and correct me. The judge chose the foreperson. Now, there are there are 12 jurors, 9 black, 3 white. He chose one white woman as the foreperson. Do you see anything weird about this? It's
unusual because normally the jury itself picks the foreperson. I mean, some people don't want to be the foreperson, and some people will volunteer to be the foreperson. It's odd that a judge would decide because the judge doesn't really know anything about the personalities of these jurors, but I don't think it's going to be fatal one way or the other to the case because the foreperson is just really the one who does the speaking up when there's an issue with the jury, but it shouldn't change any votes.
And should the viewers think anything about race in terms of that?
No, I mean, the race of the jury is the race of the jury, right? The attorneys picked that. I'm actually a little bit more concerned about the jurors have the feeling that they need to rush to their verdict.
Let's talk about that. So the judge last night, when they asked, do we have to come to an answer, one of the things he says is, if at all possible.
Yeah.
What does that mean? Isn't that pressure from the judge?
Well, I think the judge has put a little pressure on this jury from the get-go because they're not local, right? They're being bussed in, and we had court on Saturday and Sunday. You know, most judges want to go play around to golf. They don't want to be there Saturday and Sunday, but he wants to get this trial done, so he made them come in and everybody work over the weekend, including us. And I think that's sending a message to the jury to hurry up. But this is a capital case. You can't just hurry up.
Yeah, there's a lot of evidence they have to dissect, so I hope that they're not rushed through this. All right, I want to play some testimony again that you might have missed. This is from George Mister, somebody that not only knew Jessica Chambers, but was thoroughly investigated by police. Let's learn a little bit more about this testimony. That was George Mister claiming that he was harassed by police when they were investigating what happened to Jessica Chambers. He was one of the people that they looked at. Now, Jonna, as we look to the testimony of Mister, process that for a second.
Yes.
I don't know if I feel that terrible because the way that I feel about it, and I'm wondering if a lot of our viewers feel about this as well, is we really want to know how other people were investigated in this case, correct? That was what was big this weekend. Who else did you investigate? How did you investigate other Erics or Derricks or people that were connected to Jessica? We learned that they went all through her social media page, people she contacted. So don't you want the police to do as thorough investigation as possible? Yeah. Because we're questioning if Quentin Tellis is actually the person that did this.
Yeah, and that's one of the reasons why I think the entire defense case, I mean, the defense put on their whole case yesterday, and I think it all fell flat. I don't think it's going to move the needle that they called the mother of an Eric who got investigated. It's not going to move the needle that they have some other person who was with Jessica on that day or nearby that day who they also questioned. That's how you do an investigation. I'm really not sure what kind of points the defense wanted to score with these witnesses.
Because wouldn't it have been better for the defense to say, hey, listen, yeah, the police looked into me, but to be honest, they didn't really check anything. Because if they want to say, hey, they centered their attention only on Quentin Tellis.
Right, and that would have been probably a bigger point for the defense to make if they only focused on one person to the exclusion of all the other Erics and Derricks and people who were with her. That would make the investigators look bad. So again, I don't see how this is going to help or hurt the defense.
Or is it the idea, hey, listen, they harassed other people like they're harassing Quentin Tellis?
You know, define harassing. It's not, when you're investigating a horrific murder, it's not like you invite somebody over for tea and crumpets. What does it mean to be harassed when you're a suspect? And again, unless they're going to go for some sort of jury nullification, I don't see how that's going to help.
Well, we're going to have to see because we are hopefully going to be live in that courtroom. If the jury comes back with a verdict, we will go live. But we were also going to be live today in Jason Van Dyke. So stay tuned here on Law and Crime. We're going to be discussing a lot. We'll be right back. Okay, the prosecution really stressing the fact that that investigators did do a thorough job of looking at other individuals, and they didn't narrow their focus on Quentin Tellis for no reason. Back here with Law and Crime trial analyst Jonna Spilbor. John, I'm going to ask you the million-dollar question. Do you think investigators, ATF, FBI, the Sheriff's Department, did they do a thorough investigation here?
I say yes. That's my answer to the million-dollar question. I think this whole Eric and Derek portion of the program is a little bit of a red herring, because I am thoroughly entrenched in the camp that you cannot rely on what a woman who was dying, and not just dying any death, she was dying a slow and painful death, her physical body incapable of actually forming words. I'm not so sure she could understand the questions being asked of her. We had expert testimony that said she wasn't going to be able to articulate. So to hang your hats on the fact that she, quote, identified her killer as some Eric or Derek, I think is a red herring. Don't go down that road. And this is really what the prosecution is trying to hit home with the jury.
To think about the other argument to that is that she was able to utter words that they did understand, like I'm thirsty or cold. So if she's able to utter words where they understood what she was saying, and she was able to acknowledge certain commands that they were saying, for example, when one officer said, Eric, do you know Eric who? And she said no. The idea that she said what sounded like Eric or Derek, how do you discount that? This is from the victim.
I am discounting it because I am discounting all of the investigators' testimony that they were able to have a conversation with her. They might have been trying to have a conversation with her. They might have thought they heard what they think they heard. But a woman, any person in that condition, is not going to be able to provide you with reliable evidence.
Now, I don't know what's going on in that jury room, what will ultimately happen when they continue their deliberations. But if I was a betting man, I would say they're probably considering that factor in its entirety, whether or not each juror has made a decision about the Eric or Derek comment, whether how much they're relying on it, looking at the other evidence. You know that's going to be in their discussion. It is a key point in this case. And what we are going to do is we're going to take a quick break on our end, but when we come back, we're going to play a little bit more of the closing arguments in case you missed it. Stay tuned. Okay, let's analyze right now the prosecution's closing argument here with Jonna Spilbor, because there's a lot to dissect.
Right.
Jonna, let's think about this for a second.
Okay.
What makes more sense? Do you have a guy who's trying to hide being with Jessica Chambers in the night in question? Because he did it. You know, he's deleting messages off of his phone.
Right.
He's being untruthful to investigators.
Right.
Or do you have a guy that was nervous about being caught up in this investigation, knew that he was with her earlier in the day, didn't want to have anything to do with this. As soon as he's being fed more information from investigators, his memory starts to, he starts to remember new details. So do you have a guy who's trying to hide something, or just somebody who didn't want to get involved in it?
You know, maybe that's the million-dollar question, because obviously the prosecution wants the jurors to believe, and I think they did a pretty convincing job of this, that if Quentin Tellis is not the perpetrator, why was he doing all these things? Why was he lying to investigators? Why do you delete somebody's messages? When is the last time you deleted somebody's, honestly, message from your phone? And we know you have not killed anyone. I'm safe with that assumption. But why do you do that? You do that when you're trying to hide. So he's trying to hide information by not being truthful with the police. He's trying to hide evidence on his phone by deleting it. Guilty people hide stuff. That's the direction that the prosecution is going with this.
But here's another way of looking at it. So if he knew, and we had an expert who came on and said, hey, listen, he is a black man in Mississippi. There was a young white girl who was just burned alive. The police know that he was going to be with her. They could track that he was with her. He didn't want to be involved in any which way. Could you say he just got nervous? Or does that just not make sense?
You know, that's a theory that you can float if you're representing him. But when you combine everything, when you look at the totality of the circumstances, the fact that we do have some evidence that connects his DNA to, like, the key fob, for example. When you have the fact that he has burns, which he tries to explain away as hopping over a bonfire, when why weren't the burns on his feet? The burn was somewhere on his arm. You have the fact that he lied about being with her. We can prove that he was with her. He's deleting his messages. When you take it all together, who else did it?
And I guess the biggest thing is that if he didn't do it, somebody, this third party, would have had to come forward in that hour time span, that missing hour of time, have came in, killed her, and ran away.
Yeah, and then just walked away.
Which is possible, but is it a reasonable doubt?
I don't think. I think the prosecution has met its burden here, and I think that this jury is going to come back with a guilty verdict for all of those reasons.
Or it could be not guilty, or could be another mistrial, and then we'll talk about what ultimately happens if that should happen. We will take a quick break. When we come back, a lot more to dissect and analyze. All right, so Jonna, you were listening to this. I'm curious, one aspect from you before we go to our next break is, what do you see the differences between what the prosecution did this time around, in the sense like, hey, we know what the defense's strategy is. We know which way they're going. Let's try to undercut some of their arguments, including talking about who this mysterious guy at the crime scene was, this guy with the blank stare. And let's also talk about this woman who gave a ride to a hitchhiker that night. And let's also bring in a speech pathologist to talk about Jessica's words. How are they doing at undercutting the defense's case?
Well, I think the biggest thing that they did in their own favor was to bring in that speech pathologist. And if I back up for a minute, I mean, it's never great to have a mistrial, right? But when you get a do-over, when you decide to retry a case, you do get to learn from what you think didn't work the first time around. And I think without the speech pathologist, this was either going to be a not guilty or it was going to be another mistrial. It still could be. I'm not saying that it won't. But that was the biggest hurdle I think they needed to get around, because, you know, if I'm in the defense camp, of course I'm going to hang my hat on the fact that, hey, wait a minute, she identified somebody else. But when you realize that she couldn't physically do that, that was the biggest point that the prosecution needed to make this time.
If this should end in a mistrial, do they retry it? Or is there a situation where, as attorneys, as prosecuting attorneys, you say, you know what, this is one of those cases I just feel that I can't get a jury to decide one way or another. So if there's another mistrial, do they go that way?
So I have two thoughts. The first thought is, usually you get 3 bites at the apple. In other words, I've seen cases where you've had a mistrial and you've retried the case 3 times before you actually give up. Second, I think the prosecutor, what the jury doesn't know is that he is facing charges in another state. So maybe if this is a mistrial, the 2 states might get together and try to fashion some sort of deal to avoid a 3rd trial in this case. I'm not sure how that would work, but he's not walking away if this jury ends in a mistrial. So I think you have to factor those 2 things in and see what you want to do next time around. Plus, you need justice for Jessica, honestly.
Right. Because either way, even if you're in Quentin Tellis' camp, you don't want a mistrial. You need an answer one way or another about what's the fate of this guy going to be.
Yeah, you would prefer that. And for him, even if it's guilty and he's facing charges someplace else, then he's going to have his automatic rights to appeal. And so it won't be over for him no matter what. But even if it's a not guilty, he's facing charges in, I think, Louisiana or another state. Based
upon what we know, should we be concerned right now that the jury hasn't come back with a verdict yet and that they were still deliberating?
This is not a slam dunk. It's not a slam dunk at all. It's going to take some time. I wouldn't be concerned about that on either side just yet.
Okay, everybody. Well, this is definitely a big case to watch. And as you just heard from Kathy Russin, I can't believe that the foreperson is somebody who watched the Oxygen series on this. This is pretty incredible developments in this case. We are going to take a quick break. When we come back, a lot more to analyze. Okay, let's learn a little bit more about the defense's closing argument and their case in general. Let's talk more about it here with Jonna Spilbor. Do you think they're doing enough to raise reasonable doubt here, in the sense like, okay, let's explain the motivations of Quentin Tellis. Let's talk about the reliability of some of this evidence. And let's talk about other people that may have committed this crime.
You know, I watched this live yesterday, and this defense attorney, I think, did a really great job in her closing. She was just even, she was steady. But I don't know if there's enough there to raise reasonable doubt over the entire jury. There may be enough there to raise reasonable doubt for 1 or 2 or less than 12, which is all it's going to take for another mistrial, which is going to leave us kind of in the wind, as we were talking about before the last break. So I don't, for me, I'd be voting guilty, but I'm not sitting in that jury box.
But they do raise some interesting arguments that it's going to be hard to discount. I mean, yes, we can talk about the Eric and Derek, but we talked about a little bit, what's the motive here? Why, I know motive's not an element of a crime for the prosecution, but why would Quentin Tellis murder Jessica Chambers?
Yeah, so I don't recall what evidence they first of all, motive is not an element of the offense. They don't have to give us the reason why. But I want to know why. Like, obviously it wasn't over money. Was it because it was this unrequited love?
That she refused to have sex with him or rebuffed his advances.
And unless there's something really deep-seatedly wrong with him, that's not a reason to kill somebody, let alone kill them in such a disgusting way. So I don't, motive isn't going to help us one way or the other come to a decision in this case, because it really wasn't overly explained.
Burning someone in that fashion, and I know there's a question of whether this person knew that Jessica was alive or not, but considering if they thought that she was alive, it seems to be a very personal and hateful way to kill someone.
Or, yes, most certainly, unless you're just not that sophisticated and you think burning someone is going to cover up all evidence of you being present at the crime.
Well, either which way, this young girl really went through the most unimaginable pain ever. And she died from her injuries. We learned all about it. She suffered burns to 93% of her body. And we are now waiting for the jury to come back with a verdict one way or another on the fate of Quentin Tellis. And here on Law and Crime, as soon as they go live, we're going to go live. Now, I want to switch gears here. As we wait for Jessica Chambers, we are also live in a different case today, and that is the Jason Van Dyke case out of Illinois. This former Chicago police officer who's on trial for shooting and killing a 17-year-old named Laquan McDonald. The question is whether or not this was murder or a reasonable use of force by the police. I want to play some testimony in case you missed it, or if you already saw it, it's probably one of the most important pieces of testimony. This is the forensic pathologist by the defense, Dr. Shaku Tees, who is going to provide a very different narrative of what happened than what the prosecution's medical examiner had to say. Take a look. Let's break down this testimony from the defense. Back here with Jonna Spilbor, our Law and Crime trial analyst. Okay, Jonna, so she's saying that it was one bullet out of the 16 that ultimately killed Laquan McDonald, while the state was trying to say that each bullet ultimately contributed to his death. Why does this matter to the jury? In the sense, we know that he was shot, we know that he was killed, and we know who did it. So what am I not getting here?
So I think the defense is going to turn on whether this use of force was reasonable or not. Let's back up for a second. I mean, I favor law enforcement, and they have a tough job. They get up in the morning. They are authorized to kill people under certain circumstances. They do not expect to, in the course of doing their job, come home with a murder charge. And that's exactly what happened to Mr. Van Dyke in this case. So was his use of force reasonable? And I think the defense is slowly doing a fairly good job of showing that he didn't wake up in the morning and intentionally decide to kill somebody for no reason, that he was trained in a certain way and he was doing his job within that fashion.
And I guess if it was one bullet that ultimately killed as opposed to 16, it shows it's not as savage.
Well, but part of that, I think, plays into the fact that they were trained to, when they are eliminating a threat, they are trained to empty their gun, and that's essentially what he did.
Let's talk about that for a second. One of the witnesses that the defense called was this use of force expert who said there's many ways that these recruits in Chicago are taught to use of force, including two that I want to mention right here. To prevent someone from escaping an arrest who's committed or attempted to commit certain felonies, and to prevent someone escaping arrest by use of a deadly weapon, including a knife, which, in other words, they're allowed to gun down someone who's just trying to resist arrest?
Right, and that's actually not all that uncommon. I mean, think about it this way. Get out of this case for a minute. Think of all the times you have a police officer who is conducting a high-speed chase against somebody who could be completely unarmed, but for the fact that they're sitting in a 5,000-pound vehicle. They're allowed to do that, and that often results in death. So the use of force when you're a police officer is this special animal, and the defense is going to try to prove that he was squarely acting within it.
Well, I thought that was a huge piece of testimony. We'll talk about it a little bit more. Let's go back to Dr. Shaku Tees, the defense's expert, and we can learn, in her opinion, basically, how long did it take Laquan McDonald to ultimately die, to succumb to his injuries? That was Dr. Shaku Tees, the defense's expert, talking about what ultimately resulted in the death of Laquan McDonald. But, I'm back here with Jonna Spilbor, and we saw the defense bring out a lot of different witnesses over the course of the first few days. I think they've had the case for about 3 or 4 days now. One of the things that they keep showing is testimony of people who were there during the incident, or saying, hey, we saw this guy, he was carrying a knife, our life was in danger. How much does the jury take of that, in the sense that, okay, we understand Laquan McDonald was a threat that night, that he had this knife. He probably scared a few people. But doesn't all that not matter? Because at that very moment when Van Dyke opened fire, that's what we're looking at?
No.
And there were no other people in the area.
I think that testimony is going to be critical because it really ties into the essence of the theory of this defense. And that is, was this officer justified in shooting? It doesn't matter whether he shot him once or all 16 times. Was he justified in using the deadly force? And the fact that you have witnesses coming forward saying he had this blank look in his eye, he wasn't listening to commands. The one witness who said he was going to kill me because he had a knife on him. That is only going to help the defense and hopefully the jury come to its decision here.
But if there were no other civilians in the area, he's guarded off by police, and he's walking in the opposite direction of police, how do you say that's justified? So,
because there's also some special weird rule in this jurisdiction that even though this officer didn't know of any prior bad acts, for example, from this defendant, they're allowed to talk about it in trial, and that can be used in coming to the decision whether or not the killing was justified.
Maybe, but at the end of the day, you know, what was going through his mind? You know, why did he, out of all the officers there, open fire? And why did he open fire when there was also a taser unit in the area that could have subdued Mr. McDonald in a non-fatal way? These are questions that we're going to talk more about when we get back from our break. So stay tuned here on Law and Crime. We're covering a lot. We'll be right back. Okay, so that wasn't exactly what we wanted to play. Basically, what Mark Smith was going to be testifying to was that there were no signs of life, but there was a pulse, and unfortunately, Laquan McDonald did not have a pulse when he was ultimately taken to the hospital. Back here with Jonna Spilbor to talk more about it. Jonna, I wonder, you know, when you listen to the story of what happened to him and his age, and 17 years old, how much the jury thinks about that this guy was just a teenager, you know, just a teenager. And yes, he was engaging in illegal behavior at the time, but he was just a teenager. And you're talking about him, the moments he lost his life.
Yeah, you have to have, if you're a human being, you have automatic sympathy when you hear about a teenager losing their life. And you're not putting yourself in the shoes of the police officer for the moment. And I said early on, this jury is probably the worst for the defense that the defense can have, because there's actually a person on this jury who has a partner who knew this defendant personally, who works for Family Services or the equivalent out there in Illinois. And so there's a lot to overcome when there's some sort of personal connection, basically, even though it's a personal connection once removed, to this young, now deceased victim.
Now, we learned another interesting aspect of this case from the defense. It was about believe it or not, there was a knife on the streets, a shooting knife almost a knife that had a caliber to it. And this is a weapon that could shoot out. And we learned that the police knew about this kind of knife. Now, it's not clear whether or not Jason Van Dyke thought that that was one of the knife that Laquan McDonald was holding. But the fact that the police knew about this specialized weapon can maybe give an idea of what's going on the streets of Chicago.
And what's going on in this officer's mind. Yeah, the police basically got a memo that said there's a new weapon on the street. Be on the lookout for it. It's a knife that can actually shoot .22 caliber bullets. And this memo was prior to the incident happening, but that was one of the things that was going through this defendant's mind, which he's going to use to help justify the use of force in this case.
Do you think...
Could that have been one such weapon?
I mean, again, because if he's walking away, could he still be a threat with the knife?
I think, well, no, if he's walking away, he's not going to be a threat with just a knife. But I think also the testimony is showing that he was acting so strangely that I believe in the officer's mind, he thought he was going to be so unpredictable that he needed to use deadly force.
Pretty fascinating developments in this case every which way, every day, and we're going to be live in that courtroom. I want to play some testimony from Dr. Pani. This is actually, before we do that, just want to let you know that we are carefully monitoring the Jessica Chambers feed. If there is a verdict in that case, we will go live. We are expecting to maybe see some development in that case today. The jury has a tough decision. Which way will they go? Will they find Quentin Tellis guilty or not guilty, or will there be a mistrial? We'll have to see. We're keeping a careful eye on the courtroom feed. We have just gotten an update, though, and this is pretty bad. We just got an update that someone in the gallery in Jessica Chambers just took a photo of the jury. and posted it on Facebook.
Oh my.
If that is true,
Oh my.
that is a big problem. Am I right, Jonna?
That's a huge problem. That is a huge problem. That in itself could be a reason for a mistrial if these jurors don't want to be identified. How did that happen? I mean, this judge was keeping a very tight rein on the.
I thought no cameras, no cell phones,
on the court,
nothing
yeah.
was allowed. That is pretty outrageous now that I'm hearing about this. Wow, I knew there were some issues last year, in the last trial, but this is pretty bad. We're going to report back more about that when we get more information. But in the meantime, what we want to do is play some testimony from Dr. Pani, the medical examiner in the Jason Van Dyke case. This is the person who testified for the state. Let's play some of that right now. Know that right before we played that clip, I told you that in the Jessica Chambers case, we found out that someone in the gallery had taken a picture of the jury and posted it on Facebook. That is extremely problematic, and we are getting word that that person is being picked up right now, and that is not a good fate for whoever did that. I'm so confused as to why anybody would do that. Jonna, why would somebody do that?
So, good question. I want to know who did it. Was it somebody who was neutral? Was it somebody who was, on one side or the other? Whoever it was is in contempt of court because that judge has a pretty tight rein on what goes on in there. And I don't know what would motivate somebody to do that. I don't know if there's a good reason for somebody to do that. I could only think of bad. For contempt of court, you can.
Wow.
I can only think of bad reasons why somebody would want to do this. So we need to learn more about what's going on here.
Absolutely. Okay, let's switch gears, and we're going to talk. We're carefully monitoring Jessica Chambers. If there is a development, if there's a live feed, we're going to go there. Our very own Kathy Russin is there. She's reporting back to us live. But, again, the jury is going to continue their deliberations, and we will maintain our focus there and see if something happens. But let's switch gears back to Jason Van Dyke. We talked about it a little bit earlier. What else does the defense need to do in terms of witnesses? They put on people who said that Laquan McDonald was a threat. They talked about how police manual says when to use of force. And they even talked about how on the streets of Chicago, there's a knife that can shoot out a projectile. What else do they need to do?
Might have to put Jason Van Dyke on the stand.
I was going to ask you about that. Do they put him on the stand as the last witness?
I almost think they have to. I know a lot of people think, oh, it's dangerous to do that. I think in this case, because you have to know what was going on in his mind, and the best and really only way to do that is to put him on the stand himself.
Yeah, I think that they really have to. We've seen it happen so many times in self-defense cases and defense of others cases. So here, if the defense is claiming that he was trying to protect his brother officers and himself, how do you not put him on? Well, we'll have to see. The defense will continue on with their case. We are hopefully going to be live in both of these trials today. We'll update you more when we get back. Stay tuned. That is Quentin Tellis' attorney casting doubt on different pieces of evidence that were put forward by the prosecution. Will it be enough to acquit this man? We're going to have to see. We're in verdict watch in that case. Now, I'm back here with Jonna Spilbor. Our time together is coming to an end. So as we talk about the different levels of evidence for the prosecution and the defense, I'm going to ask you straight up. In your opinion, what is the most important piece of evidence that we have seen in this case?
All right. So this case is not a slam dunk, but the most important piece of evidence by far is the Eric Derrick testimony. Let me ask you something. If Jessica Chambers was already dead, so nobody could ask her any questions, given the rest of the evidence, Jesse, do you think there would be enough to bring this case and get a conviction? And I say yes. What do you
I think there's some definitely things to consider here. The fact of the timeline, the proximity, him changing the story. These are things the jury's ultimately going to have to consider. Jonna, thank you so much for coming in.
Always a pleasure.
Can't wait to have you back. We're taking a quick break. We'll be right back. Stay tuned here on Law&Crime.